Thank you all for being here. And Doug, you want to
Thanks.
jump in?
Thank you, Belinda. Well, thank you all very much for appearing today, but even more importantly for your service as a volunteer mediator for the center. These centers would not exist at all without your participation. And of the almost 20,000 cases managed at the centers last year, the nearly 50,000 people who are the beneficiaries of your services would not have had your type of service available. So I want to thank you very much. A quick note about...
Project a little more?
Sure. Yeah, apologize. I'm coming out of this ubiquitous cold that everybody has. No, it's fine.
Some tea or something?
I'm good. I've got something right here. Water, actually. Just a word about my role at the State Court Administrative Office. We are the division of the Supreme Court charged with oversight of the state trial courts. So that means the district courts, the probate courts, and the circuit courts. And we have a whole crew of people that goes out and helps courts work more efficiently, effectively, try to provide better service to litigants. But we also have a group of 3 people at the far side of the office who work on alternative dispute resolution. And that would be me and 2 colleagues. And a lot of what we do relates to support of the dispute resolution centers. So those of you on the board and perhaps some volunteers are aware that we annually grant out an award to 18 centers across the state. Yours was one of the original 12 back in the year 2000, which we've been very happy to do. Some of you have been to our specialized training programs that we put on routinely. For example, elder and probate mediation and child protection mediation, and occasionally we've put on domestic relations mediation programs. We rely on the centers to tell us what kind of advanced training they may need. I work a lot with the trial courts to help them develop their ADR programs. I liaison with law schools and local bar associations and the State Bar Association, and we do a lot of policy work in terms of developing new court rules. We have a new court rule in process that would help guide child protection mediation, and something new that the legislature created called collaborative law. There'll be a new court rule on that. And we've looked at parenting coordination topics as well. And I'm fairly active when there's legislation afoot affecting ADR as well. So right now we're in discussions with some of the Senate and House Appropriations committees to try to get more funding for the centers. In fact, my colleague right now, this very moment, is meeting with people within the House Appropriations Committee to talk about funding for restorative practices. So we have a lot of things that we do. One of them is to come out and meet with you and listen. I want to at least have a casual conversation, and I'm interested to hear what you're concerned about as we move through some slides here or at the end of the hour and 10 minutes. And I try to put together some information that I thought you might find useful or interesting, at least, as it affects our work. So I'm just going to move through these slides. Everybody probably has a bit of a handout. You're not going to be able to see some of the early slides very well in the handout just because of their detail. But I want to talk just a bit about some trends in the trial courts and introduce you to some of the statewide ADR initiatives that we're doing. A few items that relate specifically to community dispute resolution. So when I use CDRP, that stands for the Community Dispute Resolution Program. That's the program that we administer that provides grant funding to 18 organizations like yours. Just a few words on, from my perspective, what's working. And that's where I'm going to invite you to comment as well. And then talk about a couple challenges that I see just in talking this morning with Susan, I think it was, we identified the fact that more lawyers don't want to have joint meetings, and some lawyers don't even want to have opening statements. I don't know the extent to which you're hearing that, but I'm hearing it. So that's a challenge that we've got. And then a few items that I'm calling prognostications, just because I like the word. And so kind of from my vantage point, what do I see coming? What are some trends? So these are circuit court civil and divorce filings without actually seeing the numbers that are in the mid-40,000s 10 years ago to 2016, which is the data that we have most currently available. You can see that there's been a 13% decline in civil filings and a 15% decline in divorce filings. This downward trend you are going to see in the following slides. I'm always interested in mediation or when I'm in the halls of a courtroom and somebody says, well, you know, we're not going to settle this because we're going to have a trial. And I'm always fascinated to learn what percentage of cases actually go to trial, people's perception of that. And even when I talk to law students, I'll still occasionally hear, 30% of cases filed go to trial. The fact is that in 2016, 1.1% of cases filed actually go to trial. For 2017, I expect that we're going to be right about 1%. And if the trend continues, we will be below 1% in the years ahead. So for everybody that's pounding on a table, you know, I'm not accepting that, I'm going to trial, I think there's some room for reality testing. I'm not quite sure how you do that. But we really are at the point now where you can go online and look at your local trial courts. And if you're in Washington Circuit Court or is it D15? 15th District Court?
Yep.
Yeah, or whatever district court you're in. You can just go online and look at our stats and very simply calculate, you know, that in district court it's even smaller. So, you know, let's talk about how sure are you that our case is going to go to trial in an era where there are so few trials. I'll speak a little more about the implications of that later on.
Can I
Yes.
ask you a question? Because I was surprised by the reduction in the filings.
Yeah.
Have you talked about the reasons for?
This is a national phenomena. Filings are down across the nation. We can't point to any one specific factor. You know, we'd like to think that perhaps it's because dispute resolution is actually getting around and people are thinking about problem solving. I think probably a more prominent factor is the cost of litigation and the challenge or just how challenging it is to litigate. When in an era where a lot of lawyers won't take a case unless they get a $10,000 retainer, or if it's a personal injury case, they want to make sure that they can make so much money on a file. I think there's probably a whole lot of reasons, but I'm not aware of any one group that sat down and said, these are the top 10 reasons. Yeah?
Has there been a reduction in the amount of time that is being spent in the courts on these cases? Are they more complex? Are they taking longer, or is there just less workload for the courts also?
I would say, I don't have a slide on that. I would say that the amount of time that courts are spending on cases is not changing too much. On divorces, it's under 15 minutes on the pre-judgment side. On the post-judgment side, it's quite a lot more because people keep coming back and back and back, and they just take more time in those cases. But I can't really say. We look at performance measures in trial courts. They have to dispose of a certain percentage of cases within so many days, but I don't have a historical note on that up here. So, keeping with our downward trend, so these are divorces with and without children. again, you see a bit of a decline, almost 100 cases on the divorce with kids. So this is all of your district courts here combined, 14A, B, and 15, and a 21% decline. Now, some courts, when we call them up and say, how come you're not referring more cases to mediation, are saying, well, there are less cases. And in some courts, this is up to 30%. There's really been a precipitous decline in cases. But the centers are still mediating only 3 to 5% of the docket. So I'm challenging judges and court administrators with that. Say, yes, I know that your caseload is down, but you're only referring 3 or 4% of your cases to the centers anyway, so what can we do about that? I know the centers would be very happy to receive more cases. So these are, then I just broke them down by case types. So yeah, small claims in the area is down a quarter, and civil is down 34%. The small claims rate, or filing, what do I want to say? Jurisdiction keeps going up. It was $3,500 5 years ago, and it'll be $6,000 within a few more years. So some cases that would have been filed in district court will be filed, would have been filed in circuit court. More should come into the district court. Landlord-tenant is just about the same. So the relationship between landlords and tenants in your university town, there's just as much conflict now as there used to be. So any questions on these just few stats? Yeah.
A quick question. Do you see, do you have any statistics on arbitrations? As the filings have come down, do we have more arbitrations that perhaps weren't initiated through litigation as such?
We do not have stats on arbitration because that's usually managed by contract, and those cases don't get filed.
Right.
The only cases that get filed are where somebody's trying to contest the arbitration clause in a contract, which is fairly small. So we do not have stats on that. But I think another trend in response to Zena's question is that there's more pre-filing mediation going on. I talked to active mediators in Southeast Michigan in particular, and they say they're getting called far more frequently pre-filing to meet, which I'm very happy to hear. But those are also cases that are not going to get filed. Yeah.
Does this have any effect on the number of judges?
Does this have any effect on the number of judges? It will.
It will.
Under our prior Chief Justice, Justice Young, he had an initiative that he took to the legislature to reduce the number of judgeships by, was it 34? Did anybody remember it? 34, I think it's 34. We have a formula by which we calculate caseloads and time spent, and some jurisdictions have gotten 1 or 2 more judges, some have gone down. But if more people mediate pre-filing, that absolutely will fit into our formula calculations for determining the number of judges. Yeah.
This may not be a question you can answer right now, but I think some of the pre-filing notion of some case types creates some anxiety among centers and volunteers. Like, what are the risks? Are we taking? No one. I'm going to use domestic relations as an example. There's this debate on should the couple file first, then come to mediation, or should you mediate prior to filing, and how the intersection of that. And I think having some clarity around what it means to work on a case pre-filing and what risk might be there, if any, might be helpful. And I don't know if any of the mediators here have thought about that. Most of our domestic cases have had some contact with the court by the time they come to us, but we're beginning to get calls as people think about, I haven't been to court yet, but we know we want to get a divorce. What do we do? You know, kind of is the dilemma.
There's a whole lot of issues wrapped in there, one of which is by statute, if you do not have kids, you have to wait at least 60 days after filing in order to get a divorce. If you have kids, you have to wait 6 months. Under a new court rule proposal, you would be able to file a notice with the court that you're going to engage in ADR or collaborative law to start the clock. Because if people spend 6 months or a year mediating before they file, and then they file with a consent judgment, then they have to wait 6 months, right? That's very challenging for a single person, let alone a person with kids and all your finances are tied up. So that issue's out there. There's a whole lot of issues related to self-represented litigants, which are increasingly a large segment of people coming into court, and how do we provide them with legal resources and the whole legal help, MichiganLegalHelp.org packets that they can file. Anyway, we could spend a whole day just talking about domestic issues, and at some point we will.
And I think some of those things are spilling over to other cases as well.
Yeah. Relatedly, so now we're going to talk about just a couple statewide initiatives. I just want to underscore, and I'm sure Belinda's brought this to your attention, but we now have a court rule and a statute that requires us to be attentive to domestic violence throughout the process. That means from the very first phone call to our very last contact, we have to make reasonable efforts to screen for the presence of coercion or violence. So this is just so significant, and I'm hoping to launch a couple additional efforts this year to expand screening to elder cases, to child protection cases, and even to general civil cases. Probably those of you who've mediated quite a bit can point to at least one, if not a lot of cases where you have felt there's some type of coercion going on here, and then you caucus and say, what's really going on here? Anybody? I see some nodding heads. Is that familiar to anybody? So we want to come up with some means, just like we do with the domestic cases, to ask just a couple questions up front. Is there something going on here that you'd like us to know about, or would be helpful that we might not otherwise learn, but for asking? Yeah.
So suppose you feel there is some, does that mean that you can't mediate?
No, not necessarily. We have we call it the domestic violence screening protocol. Has a lot of questions. It has some strategies for if somebody really wants to mediate, but there has been coercion, how to do that in a protected manner. So that again is a whole other substantive topic that we could spend a lot of time on.
We have one door, it's complicated.
But there may be cases where absolutely not. You would not want to do it. But there may be cases where the person wants to, because the alternative is to go to court and take the stand and get cross-examined, and the other person's in the room and all that stuff. So, I mentioned a couple minutes ago that we're working on child protection mediation court rule. Do you have child protection mediation cases here?
No.
Not so
We do
much?
peacemaking.
You do the peacemaking. So, at other centers, I won't spend a lot of time on this. We bring, the 12 to 15 people together who are involved in child protection cases, and we run it just like this, in a room with several mediators, and we have a facilitated conversation. It's very similar to the special ed cases, actually, for those of you working in special ed cases. So it's a bigger group dynamic, and it's how the whole idea is deriving a permanent outcome for the child who's been taken into the foster care or the DHHS system, right? So your outcomes are going to be either returning them home at the earliest possible moment or placing them for permanent guardianship or foster care. So far, we've been doing this at some centers for about 17 years, but we haven't had any court rules about it. So now there will be, probably by summer.
And I would just add that even through peacemaking, we're experiencing those kinds of outcomes.
Oh, okay.
Yeah.
Just a quick note about parenting coordination. For those of you working on domestic relations cases, there is a statute that outlines what parenting coordination is. We brought together a group of people to determine if we needed a court rule. But in a nutshell, do we have any parenting coordinators here? No? So these are folks, they're usually lawyers or people with professional degrees in psychology, social work, what else, you know? Is that kind of it? Professionals with social work backgrounds or lawyers, psychiatrists? They work in high conflict, with high conflict people. So in a divorce where the people are just so intractable that they can't agree whether the sun is out or what time of day it is, rather than running back to court and filing a motion and then having an investigation and then coming back to court, 2 months later, the idea is that, if you disagree over where and what time you're picking Johnny and Susie up this Friday, you get on the phone now with the parenting coordinator, and the parenting coordinator makes the decision. So this new rule and statute will help give some, when we get to that point, we'll get some guidance. As of the moment, there's really not enough of this practice around the state for us to pull together a comprehensive rule, but we're committing to bring people back in a couple of years and coming up with a new court rule at that time. So, but I mention this because those of you who work on divorce cases, if you have a couple like that, it's always an option out there. It may be an expensive option because the parenting coordinators charge a professional rate as well. In May, I'm bringing together a group of 60 or so people. We're going to look at an evaluation of mediation and case evaluation practices. And then basically I'm going to ask these folks, kind of where are we with ADR in the state right now, based on the evaluation and their experience. And then sort of a futures type of question, where do we go from here? What do we want our ADR services to look like 2, 3, 4, 5 years out? And then provide recommendations to the court administrator and Supreme Court. So the preponderance of the group is actually going to be users of ADR. So insurance companies, lawyers who take their clients to mediation, and a certain number of mediators. But the idea is to bring in the users and say what's working, what's not, where do we want to go with this? So I think it'll be a pretty interesting conversation. And we will publish an outcome of that as well. So just a quick snapshot of some of the things going on. We're just now crunching last year's number for the community dispute resolution program. But as I said earlier, we're getting to the 20,000 level here of cases referred to the centers. Now, not all centers result in mediation, as you know, because we sometimes can't contact another party or people settle before they get to mediation. But we had 15,000 cases where mediation or conciliation or facilitation was actually held. That's a lot of work. So I'm really, really pleased with the consistent rate that you're getting in cases of around 75%. For those of you who mediate exclusively in the district courts, does that sound a little high? Yeah. So, usually we see, like on day of hearing mediation in court, it's right around 50%, 45 to 55% window. Does that sound more right?
Yeah, we're within it.
Yeah. But I don't feel bad about that because in a lot of cases, after they've met with you, if it's not a day of hearing type of mediation, another 25% of people are likely to settle. We did a study on that. So you've planted the seeds for settlement in a great number of cases. So only another 20 to 25% of cases actually go on to meet with a magistrate or a judge. So please don't feel bad about, around a 50% settlement rate. I think that's great. It's people use that experience to go on and in many cases settle later on. We're still spending less than a month in cases, and that number includes special ed cases and complex guardianship cases, and the complexity of the cases at the centers are increasing too. So that's still pretty cool. When we go and talk to judges and say, I can't take the time to send people out to mediation. I've got to move my docket. I say, you don't have 25 days in here somewhere that you can send parties to go reach a resolution of their own. Oh, well, okay, I guess we can do that. So they're thinking like in other, like case evaluation, when people go out for that, it might go for 3, 4, 5 months. And that's not time that most judges are willing to give up. But if you just say, 3 weeks, or 3 weeks and 2 days, or whatever it is, that's all we're asking for. Most judges are good with that. Most of the cases are around an hour and a half. I do want to say that that's probably atypical. It'd be probably a little higher for in-court small claims and landlord-tenant day, right? Does that sound a little high? Or do they take about an hour and a half? Think? Okay, good. I'm nervous about some courts where the magistrates are just kind of at the door saying, look, the judge wants to leave, you got to wrap this up, can you do this in 20 minutes? And it's like, so we've got some courts and judges like that make me nervous. But this also includes some school mediations where kids are mediating down the hall, and a lot of those cases take 20, 30 minutes. So, and then we've got the special ed cases that can take 5 and 6 hours, right, if not longer. So it's a better number would show this by case type. Anyway, average amount of settlement is still under $3,000. If you're ever talking to a lawyer who is nervous about your work and that they're taking business away from lawyers, you'd say, well, you want to be paid your professional rate to mediate a case that's on average less than $3,000. We're not going to ask people to pay $300 an hour with a private mediator on a $3,000 case for the most part. But if people want to, they can. So I think to some degree the bar has this perception, some members of the bar, that we're taking business away from private mediators. Our numbers just don't bear that out. There is the occasional case where people come in, they want to use your service, and it's a homeowner purchase buy-sell transaction, and it is a $45,000 claim. But I think those are more rare. And you've contributed 17,000 hours of volunteer services. Just the people in this room have contributed 17,000 hours of service. No, I'm just kidding. This is a statewide number, but very impressive. So I've touched on a couple of these. A couple trends here. The number of post-judgment parenting time disputes is increasing. Friends of the court are increasingly comfortable with your services across the state, and they're saying, look, these people, these frequent filers that keep coming back to us every holiday, you can have them. And the reason for this is that typically a friend of the court can only spend 20 minutes or 35 minutes with people, and they can only help people resolve the issue that's on that piece of paper. They can't go back and talk about what happened 10 years ago, 5 years ago, or whatever, or other issues. You can spend time with them to talk about what's really driving this dispute, right? So you can take a couple hours to do that. So the Friends of the Court are increasingly happy with this work. More and more work with schools. I think we counted 10 centers now that have some type of program with schools. Most of that is restorative practices. And you've got some work with schools here, right? Yeah. And as I said at the beginning of my remarks, it has caught the attention of the legislature, at least to start talking about providing funding to increase this amount of service. But clearly the centers are being asked by more schools to come in. They also have a statutory mandate when they're considering suspension. They have to consider alternatives to suspension, and one of those is offering restorative practices by statute. So that's prompting schools to call the centers as well and say, we don't have any expertise to do this. Can you do it? And the centers will say, yes, can you help us fund it? Because it typically requires putting a person in the school. So a lot more of this going on. I've mentioned child protection earlier. Elder law issues. This is a growth area, and I think we'll be seeing more focus on this for the selfish reason that I'm getting older. And I'm going to need mediation at some point myself. So, no, really, probably many of us in the room have elder relatives, if not parents, cousins, brothers, sisters, whatever. And it's complex. you know? I mean, even for me with a law degree, having worked on elder law issues, the challenges that elder people face are just almost insurmountable with the paperwork and the agencies and the phone calls, not to mention the diverse interests that children may have, flying in from California, New York, and Texas to complain about the local sibling who's actually doing all of the work 24/7, right? So, so we're focusing a bit more on that, and I think we've got a training coming up in the months ahead here. So a couple comments on what I think is working. I think the face-to-face model is still fantastic. You all could probably share multiple stories about the magic that happens when people come in all tense and nervous and frowny and spend some time together, and not that they walk out hugging necessarily, but they've been able to put it beyond them, right? They can get on with it at that point. And we talk a lot about that face-to-face dynamic as we talk more and more about online dispute resolution, which I think is a bullet later, but I'm going to talk about it now. Actually, you live in a jurisdiction that has online negotiation of traffic tickets. Has anybody used this? I'm not going to ask you to admit that you've gotten a traffic ticket. I guess that would be improper. But so if you get a ticket around here, you can go online and see if your ticket qualifies for a negotiation. And the system will tell you that you qualify or not. And let's say that you got a 3-point ticket and that has a $300 fine, just to keep it simple. You can go in and say, well, as an alternative to that, I would pay $100 and I would like 1 point. And click send. And the police officer, I know, you just got a ticket, didn't you? Secrets. So the police, a member of the law enforcement, the city attorney or prosecutor, and the magistrate or judge will look at your proposal, and they'll look at your driving record, and they'll say, probably not, but they might, and they're not going to negotiate the money for the most part. Why? They need it, because this funds libraries and all kinds of things, right? They will generally negotiate the points unless you have 12 points already on your record. So they might come back and say, no, we want you to pay the money, but we'll give you 2 points. So you go online and accept it or reject it. If you accept it, you type in your credit card number and you're done. 45% of the people who do this do it after business hours, so they're not having to take time off from work to go to court. And I know some courts, they schedule 30 cases all at the same time, unfortunately. So, and the data so far, this is only a couple years old now, suggests that a higher percentage of people are paying their tickets than if they go through the regular process, and they're paying them sooner, so the funding unit is happier about that. And so this is going on in about 20 courts right now. So I'm in talks with the group that's doing this, which actually started as a think tank project out of University of Michigan. We're talking to that company about expanding the service to online dispute resolution, and we're talking to several other vendors as well. And the model there is basically to take what we're currently doing and giving it an online presence, meaning that somebody could start a dispute online. Has anybody used the eBay dispute resolution system? Okay, it's very similar. eBay?
eBay.
Yeah. Okay. You have?
Yes.
So it's very similar. You would have an opportunity to directly negotiate with SOBA, with the let's say that you bought something, right? So I would be able to directly go online and tell the seller, the wrong thing arrived or arrived damaged or whatever, and here's what I want to happen. The other party would come back and say, well, it was perfect when we left here, no, we're not going to deal with you. Then, if you wanted to, you could directly engage a neutral. And if you click the Engage a Neutral button, the center will get a notification that somebody wants a mediator, and they'll be able to access this system and do an intake. And if they want, they could negotiate with the people what we call asynchronously, meaning one at a time. You know, so like at 12 o'clock, I'm going to correspond with John, and 2, 3 o'clock with Susan. Or they could get them both on the screen at the same time and do a Skype or go-to-meeting type of mediation where everybody's on at the same time. And you could go into caucus this way, and you could basically conduct it as a mediation. It's just all done on a computer screen. Some courts do this right now with post-judgment front-of-the-court disputes where one party is here and the other party has moved to Iowa or whatever, right? And they need to make arrangements. So we're just looking at this right now. We have some proposals in from a couple vendors. Cost is an issue. And there's also the element of if we build it, will they come? Some people argue that it will provide greater access to people to resolve disputes who don't want to take all the time and trouble to file a lawsuit, so that it makes achieving a just result more accessible, is the argument.
Do you have the statistics for settlement to compare to the current statistics?
No. There's one court that's now doing this that I'm aware of in Columbus with a limited type of cases, and I don't remember the settlement rate. But I know with eBay it's extraordinarily high. Just this vast number of these things shake out, just from parties negotiating on their own. And eBay then has a system of assigning cases to people. So it'll be an experiment, and we'll be looking for a couple pilot sites to test this out in. We've thought about maybe landlord-tenant and doing it in a university town. One of the judges in East Lansing says, no, it wouldn't work there. The landlord just wants the student out. They don't want to negotiate with them, which I thought was kind of curious. So, and then I said, well, in Ann Arbor, people are much more heartfelt and friendly,
Well, I think also there's the element of the parent who pays the rent.
Yeah. Yeah.
So their ability to access or to not come to town.
So moving on, we still have a very high satisfaction rate with your services. When the center conducts assessments of how satisfied are people, we're well into the 90th percentile, even though the overall settlement rate at the center might be 65%. So what's happening there? 95, 98% of the people are happy with the service when they only reach agreement 65% of the time. Why?
Somebody listened.
I feel like the process was fair and helpful.
Yeah. Some call it procedural justice. They're happy with having somebody listen to them, So a lot of times in law offices, I talk to clients and people who've gone through mediation. They'll say, that was the first time, despite my having worked with this lawyer for 2 years, that anybody actually listened to me tell my whole thing. Because, when you meet with a lawyer, frequently the lawyer is concerned about the clock, and they'll say, well, that's kind of irrelevant, and that's never going to be considered, and so we're not going to go into what happened 10 years ago. And people get shut down frequently when they speak with their lawyers, unfortunately. So you give them the opportunity they've been looking for. And again, even with that settlement rate, a significant number of people go on to settle later, even if they haven't reached an agreement with you. Certainly the centers offer, as we talked about earlier, a quicker case disposition time, and as I mentioned earlier, you're managing more complex cases as well. So I'm seeing a trend at quite a few centers focusing on more complex cases, and for a variety of reasons, spending a little bit less time in the district court small claims arena. Couple of the challenges here, we've talked about this first notion at a director's meeting where after we train people and people become comfortable with the process, we sort of develop our own style and and this works for me. And we get nervous about that for a couple of reasons. One is that frequently we pair a seasoned veteran mediator with a newly trained mediator. And when what the seasoned mediator is doing doesn't resemble what the new mediator was trained in, they come back and they say, what? What? So a lot of the centers, are kind of doing a back to the basics kind of thing. Look, this process is tried and true. It works. I know you got your thing and your way of, and there's always the challenge of particularly lawyer mediators who want to kind of cut to the chase and tell people what to do, right? And what this judge is going to say or do. And we have to pull them back and say, no, that's not this process. That's a different process. So there's this, this isn't really new, but for some of us who've been mediating for almost 30 years or whatever, we do tend to, this kind of works for me, and we kind of veer away from the process that works so well. It's been a challenge for many of the centers to diversify their caseloads. We, of course, started out as a very court-focused program, and that's fine. But these were community mediation programs, and there was a lot of thought that community also extends beyond the court. So outreach to non-courts has been a real challenge, again, for a variety of reasons. But I'm noticing that a handful of centers are spending more time now looking at marketing to different parts of the community outside of the court system. So I think that's really, really nice as well. Program funding remains a challenge. At the highest level, we had about $2.1 million to disperse among the centers. Last year it was about $1.4 million. So we're down about $700,000. And that's because of those earlier slides where you saw the case filings going down. The money for this program comes from case filings. So it's what is the word? Oxymoronic or something like that. The more people we can prevent from having to file in court, the more we shoot ourselves in the foot financially. So that's why the centers are banding together and increasingly talking to their legislators about this challenge. Fortunately, we're at a growth. While the centers are on a growth curve in terms of the number they manage, the courts are on a downward cycle. So we've got to address this funding issue at some point here. Any questions about any of these? Yeah.
I'm curious. You're talking about the centers banding together to market and things like that. And I know your budget is very tight because of the way the funding is set up. But it sure seems to me like if there could be some kind of coordinated statewide marketing blitz or whatever, or a public service announcement. Because I am astounded. All the years I've been involved with this, I tell people I'm a mediator. They have no clue what that is, and I just feel like Michigan could really benefit from getting the word out there about mediation, and then also about mediation. These centers, and because we have so many talented volunteers who are very underutilized, and so we're as a center we're out there trying to talk up our programs, but I'm just wondering whether that's a possibility at all.
Yes, and we have done that more so in the distant past. When we have these conversations with the center directors, I don't know that we asked last year, but we would say, we can certainly have marketing initiatives, but the money to do that would come from the amount of money that's available to you locally. So we have kind of put it to the center directors to say that if
we say no.
And you say no. So if they came together and said, we want to spend $80,000 on this PSA, newspaper, whatever, video marketing thing, then I would say, okay, we'll help do that. but appreciate that it comes from a pot of money that's available to send out to the centers every year.
I would actually, I have two kids in high school, and I'm horrified by how little they know about what a court is, mediation, dispute resolution, any of that. You know, one lecture devoted to that in the high school would be enormous.
Well,
And they're in government. I mean, every high schooler has a semester where they have to take a course on government, how to deal with government and basic stuff, isn't it? So,
yeah.
And that's just to follow up with my question. I wasn't talking about taking it out of the pot. That's what I'm saying is, can we think outside of the box of how can we do that? You know, is it approaching the schools and trying to educate the kids, or you know, how can we do it outside of that very tight, you know, purse string? You know.
Well, I'd be happy to be part of that conversation.
I was going to say, just as sort of an aside, one of the Oscar shorts that was nominated this year that's being shown at the Michigan right now is about a domestic situation. Well, it's about an elderly couple, and I don't know if anybody saw it, but and it was actually made by Laura Checkaway, who is a local from Barry Checkaway, Barry Checkaway's daughter. But I think there might be some media opportunities that way.
What's it called?
I think it's
Edith.
Edith.
Oh, is it the one with Helen Mirren?
No, this was actually a documentary.
Oh,
Edith and Eddie, I think it's called.
Yeah, it was one of the nominees for the Academy.
Right. Maybe we need a mini-series. Mediation mini-series.
So we need actors.
Well,
Price is going up all over the place. Is there a thought of adding $1 more to each case to fund ADR?
well, the strategy in our office, and the centers can certainly approach this issue on their own, which I think they are, and going to legislators. The problem with the filing fee is that once there are about 8 different things that are funded out of the $150 circuit court filing fee. There's judge's retirement. There's, you know, I can't remember all of them. CDRP is 5% of that $150. Once you go in and start talking about raising that, then the other 8 people come in and say, let's raise it. And now you're talking about a $300 filing fee, and it's a bloody mess. The last time we did this, it really was challenging. And so the leadership in our office is very reluctant to open that up. Plus, you know, they talk about access to justice and how much do you have to pay to start a lawsuit. And they now have motion fees. You know, every time you file a motion, there's a fee for that. There's so many fees that people are concerned that we're actually keeping people out of the court by making it cost prohibitive. But no, these are all great comments, and I think a good conversation is how to think about, you know, marketing differently. And I don't know if there's an association of centers. I don't know if they're talking about collective marketing.
Yeah, so there are 18 centers in the state, which we're a part of that network, and it seems like just a few years ago we sort of came together and filed as an association so that we can begin to work together. And so we talk about marketing and back of the house kind of cost administrative things. How do we work together to reduce our operating costs, get marketing, launch programs, all of those things. And even in that context, though, the cost of doing that is still a barrier. You know, whoever does it, you're gonna have to pay for that marketing. So how do and because of the structure of our centers, and some centers their grants are less than $40,000, right? So how do they remove money from their budget to set aside to collectively pull together? It's a humongous challenge. I mean, you're talking about, you know, $5,000 in many ways sounds like nothing, but when it comes, but for our budget, our DRC's budget, that's huge. So it's just a challenge all the way around. I think one of the things that intrigues me is how we think about alternative dispute. What is alternative dispute resolution? What other kinds of offerings can we have that will count for a scale case. So I'm happy to hear that you're thinking more about restorative practice circles. But are there other things that you do in the dispute resolution world that help people get to a resolution or some mutual outcome that we're not exploring that might be helpful to what we do? So I think there's a little bit of a tension between what we do to satisfy a grant and what we desire to do because of our local needs, and how do we frame it in such a way that meets the broader definition of dispute resolution. I think it's just a part of the innovation, growth, and evolution of services. And Coca-Cola was just Coca-Cola, and now it's the beverage and healthy beverages. It's Dasani. It's all these other things. So and so I know that it's a challenge all the way around, even in your office. But that concept of they can step back and do some research and development, what corporations do, but we just don't have that luxury to explore and see. It just feels like we don't have that luxury. So.
Yeah. Well, yeah.
Yeah, I mean, I sort of think in two areas. One is there's the more formal legal process, and that the centers are a support to current court-related entities. And there's this whole other area where the centers are involved in reducing and resolving conflicts in the community that may or may not end up in court and law enforcement. And the real issue is, how do you increase the whole pie? And I'm wondering what the court can, or the court administrative office can or is doing to work on the whole pie of conflict resolutions in Michigan. I mean, are you working with legislators, or have you put your stepped into this issue actively and said, hey, this is an issue that goes beyond the actual operations of the court system, but certainly covers the rest of law enforcement and all sorts of other issues, and these centers have the skills and can really
Sure.
lead there.
So this year we put for the budget cycle that begins next October, we put in a $1.2 million budget proposal into Department of Budget and Management. That's the first tier where budgets get started. They have committee meetings, they have staff who review documents that we prepare. We made an argument based on inflation and the declining filing fees that were down, as I said earlier, 700, and then we added another, what's the difference, 600 something, 550, to expand center's capacity. We didn't survive that, so their recommendation, they made no recommendation to the governor. The governor's budget then comes out, and not surprisingly, our proposal was not in the governor's budget. It was right about that time that the centers started their own initiative to start talking to their local legislators and the critical people on the appropriations committees. So that was very good. That was very helpful. I think it's the first year that they've made such a concerted effort. Very on message. And most recently, as I said when I started, we've gotten the ear of a couple key people on appropriations committees who are saying, probably we can't get you 1.2. We don't even know if we can get you 500,000. But we're very interested. And oh, by the way, what's this restorative justice stuff in schools? So, we're looking for any kind of a hook. Had they said...
And I would say, and so we did our outreach too, and our representatives are on the Appropriations Committee, Ronnie Peterson and Yusuf Rabi folks. So if you know them, talk to them. We've done the outreach to put it on their minds, but you can reinforce that. So I'm sorry.
So they've expressed, interest. We got invited at 3:00 yesterday to go to a meeting with the committee chair's staff this morning at 11. So we were preparing stuff until 10:48 last night to give to them. My colleague is done with that meeting by now, so I'll have more to share later, but the answer is yes. And for the last number of years, we have put in funding proposals, and given everything else, that legislators have to deal with, it's a challenge. So when they say, look, we've got all these juvenile lifers that we need to come up with $700,000 so that the state appellate defender office can find lawyers to represent those kids, do you give it to the lifer kids to maybe get out of jail, or do you give it to CDRP, or do you give it to the pothole fund? So I appreciate that it's a challenge. They have to make these calls, and the amount of revenue they have to work with is a moving target, because they had a revenue target meeting in, I think, early January. They're going to have another one in a couple months to know how much money they actually have to work with. So it's kind of, it's like our own having to make a budget, not knowing how much income we're going to have. It's like, okay, good luck with that. But anyway, yeah.
I was just thinking about the videos that Macro did for the state of Maryland when they had a huge initiative of trying to get awareness of dispute resolution in Maryland. It must be 5 or 6 years ago. But the videos that they did are fabulous. And I don't know whether there's an easy way to transfer the information about Maryland to information about Michigan.
We've looked into that. In fact, I think it's been maybe 15 years.
Is it that long?
No, it's a different initiative.
Okay.
We did create some public service announcements. In Grand Rapids, they had like $50,000 from the Grand Rapids Foundation to do table tents at restaurants and billboards and other stuff. And when we asked the directors the impact of any of this, nobody could attribute a single case to having seen a PSA or billboards in Grand Rapids. So that was then, and it's not. I'm not saying it ought not be tried now, but then we get back to the cost.
Well, that's why the video, I don't know if anybody's seen those videos, but they were really beautiful, because what they showed was a dispute.
Yeah.
And then said, go here.
Okay.
They were great.
Well, I'm happy to join a conversation about marketing anytime, so whether it's at a board level or amongst different centers. But let me wrap up with just some, what did I say, prognostications, things that I think might be happening. Hopefully I'm thinking them for some reason. So we're going to be talking a lot about triaging in the court system. This is kind of the hospital process of what happens when you go into emergency room, right? And when I ask law students that question, what's the first thing that happens? What happens when you go to ER? What do you think they say? You sit, you wait. And then they say, okay, what happens after you do that? You wait some more. Yeah. So, we're gradually moving away from this one size fits all, where you file a case and you get headed toward trial automatically, because we know that trial happens only 1% of the time. So you're going to see a lot more activity at the earlier end of litigation with finding out what kind of dispute is this, how far apart are you, what kind of judicial resources do you need to help you solve your problem, when can you go to mediation, when can you identify your neutral. If you can't do that, do you want to go through an expedited track where within, let's say it's a $150,000 dispute, would you want to go on an expedited 3-month track where you have limited discovery, limited depositions, and if you have mediation, and if mediation doesn't settle it, you go to a 1-day summary jury trial, and you're out in 3 months. So we're coming up with a lot of different ideas for how to help people better fit a dispute resolution process to what kind of dispute they have. Frank Sander, who just passed away a couple weeks ago, used to say it was called fitting the forum to the fuss. So we're all about that. Lawyers are looking at alternative billing practices. If we get people into mediation and we settle it before we even file the case, where do I make my money? So that's on the minds of many lawyers. I get it. Michigan is right in the process of developing e-filing. In fact, we now have it turned on in Oakland, Wayne Grand Traverse, handful of others, and within 4 years, all courts will be e-filing. So, on the horizon, we will have a lot more information available about what lawyers are doing because we have their professional number. And we could go in, for example, and say, Attorney Ball, you keep telling me you're not going to accept this number and we're going to go to trial. Let's see, what's your P number? Oh, I don't see that you've tried a case, in a decade? Can that be possible? So, we're going to be able...
Yes.
Yes. And correspondingly, we can type in the P number of the judge and say, well, how many cases of this case type has this judge tried in a period of time? So we're going to have a lot more information instantly available to kind of level the playing field, right, with information. And I think it's very cool. Now, that's out there, so don't quote me in the newspaper as happening tomorrow. But it's certainly going to be doable. This notion of collaborative law, which we don't really have time to get into, but it's the idea that you engage parties to settle your conflict. Isn't that amazing? That's what I thought I went to law school to do. The idea is that you hire lawyers solely to come up with a consent judgment, and if they don't, if somebody has to go into a court on a contested issue, those attorneys have to resign. So it takes away that bifurcated notion of lawyers both having to try to settle a case but preparing it for trial. So right now it's just in domestic relations and a little bit of guardianship, would you say? Or probate. Yeah. But there's no reason at all why you can't take this notion into any other case type, particularly commercial cases. We're just hiring lawyers to settle this thing. That's your sole focus. Don't worry about taking it to trial. Not your issue. And if you can't, if you come back in 2 months and say you can't do it, fine. We'll hire other lawyers. So it's really an intriguing notion. So, majority of lawyers with the most trial experience will be leaving the practice of law just because we're aging out of the system. So, the incoming, say what?
Majority?
A majority of attorneys with experience. Well, keeping in mind that we're only trying cases at the rate of 1%.
Yeah, I guess.
Nobody tries cases.
Nobody tries cases anymore. Correspondingly, the incoming generation of lawyers will not have tried cases.
Yeah.
Right? And even more scarily, if that's a word, the incoming generation of judges will not have tried cases. So we've got lawyers and judges, none of whom have hardly any, if any, trial experience. We're trying to value cases on the way we used to value them, which would be seasoned lawyers saying, well, here's what a jury is going to do in Washtenaw County. Well, they're not going to be able to say that anymore. That information is gone in the future, right?
It's already gone.
Yeah. And with the increasing number of cases being mediated that have confidentiality statements, so we're going to have all of these confidential settlements where settlement values are not going to be available, right, to the bar or the general public. So how are people going to value their claims and defenses in the future? I don't know. I just throw that out there. But it's going to be very, very interesting dynamic. On the plus side, more attorneys entering the practice will have had mediation, if not in middle school or high school, then, in some course or even the 40-hour training. In a room full of, I think there were 60 new judges that I was talking to. I asked how many had gone through the 40-hour training. 9. 9 judges, new judges, had gone through the 40-hour mediation training program. I thought that was incredible. So the affordability gap, we call, is how much are lawyers charging versus how much can people afford. So this number just came out a couple days ago. The average hourly billing rate for a lawyer is now $250 an hour. The hourly median income of a U.S. worker is $24.50. So we call that the affordability gap. And as you can see, that number just keeps going up. So I think that's where another positive sign for mediation is. I mean, it's sad that people cannot afford lawyers at this point, but at least there's a system in place to help achieve a just result of a conflict through our process and through your work. So we have a couple of new things happening in the legal profession that I hope will help. Some states now have limited licensed legal technicians. These are like nurses with the advanced degrees that can prescribe drugs, right? So,
Or physician's assistants.
that's it, physician's assistants, thank you. Some states have this in the legal profession where you're able to give some type of limited legal advice and not have spent 7 years of education trying to get there. Now, we do have unbundled legal services in the state as of a couple months ago. So this is where people wanting a divorce would go to a lawyer, and the lawyer would typically say, I can only represent you for the whole divorce, start to finish. I can't just represent you on this one thing. Now they can do that. They can, by contract, they can say, here's the scope of my representation of you, and instead of needing a $10,000 retainer or whatever, it might be a $2,000 retainer. There's also a mechanism on the State Bar website, a new program for people of limited means. That's the word. Those are the words they use to find lawyers who've agreed to represent them for $75 an hour.
Is it modest means or limited?
Is it modest means?
In this county, it's called modest means.
It might be modest means.
Yeah.
I think you're right, Sina. Thank you. So that I hope will help. A lot of the judicial and legal literature is a buzz about computers and artificial intelligence stepping in to resolve routine legal questions. That's on the horizon. Right now, we have a lot of online legal forms and packages through MichiganLegalHelp.org. That's all coming out of Ann Arbor, actually. It's very highly recognized around the country. And as I said earlier, I suspect that more and more lawyers will be using mediation pre-filing as clients become more savvy, and they know, there's clients are starting to see these numbers, knowing that only 1% of cases is going to go to trial. A prospective client is going to say, why are we going to spend all this money to go to an event that isn't going to happen?
I'm curious, 2 slides back, you had the average lawyer's hourly rate. What is the average? Do you have an average mediators? I mean, it seems like that would be beneficial to know to support the
On the private side,
Yeah.
it's the same. I'm not aware that, maybe some lawyers are charging less when they're mediating than their legal rate, but I've not heard of lawyers doing that. You charge $250 an hour here, don't you? No, for the video, they don't do that.
We don't do that.
Okay, a couple slides left. So I mentioned earlier, the trend continues downwards. I think we're going to be down to a half of 1%, maybe within 5 to 7 years. Some case types are already at a half of 1%. If you just look at case by case. Related to the earlier comment about e-filing, as lawyers, when people talk to us, and I think even at the center it's a consideration, we have to talk about how public do you want your conflict to be. Because at some point, everything that you file in court will be searchable and available to everybody on the planet forever. And there will be companies that it is their business model to aggregate these bits of information. So if you're a mega law firm with and you file all over the country or the world, there will be some type of consolidator that can go look at everything that you're doing, and your win-loss rate and all these things electronically. So it's just like now, for those of us who are involved in hiring decisions, we go look at what the prospective employee's social media pattern looks like, right? We looked at their LinkedIn profile, If they have a public Facebook page, we see, we look for all this stuff. And people will be doing the same with litigation. I've talked about triaging. We have this case evaluation process that's out there. I don't know that we need to talk about it because it really doesn't affect us at the center, does it? No. Okay. Suffice it to say, it's a fairly archaic process that I hope goes away at some point, and I'm actively working to do that. So yes, this is a notion, this is actually just a flip-flop of some of the earlier trends. Judges will have had less trial experience, but more ADR experience. So on one hand, it's a good thing that they know more about ADR and they're able to help parties select which cases. But on the other, they may be more nervous about trying cases. So we talked about online ticket negotiation. Excuse me.
Doug, do you think that just like lawyers, judges, you may have settlement judges and trial judges?
I think that's a cool notion, and some courts have experimented with that over the years. So usually by case type, like in Wayne County, they would have the asbestos judge. In Michigan, well, we also have the business courts in Michigan now, so we have judges just assigned to business cases. That may evolve that way, So the need for physical courthouses may decline. The more, the less people need a physical courthouse. A friend of mine works at the federal level, and she did a study of federal courthouses a couple of years ago, and concluded that federal courthouses, the courtroom itself, was only on average used about a half a day a week. So we've got these mammoth structures out there that we're keeping up where they're just, they don't have trials to speak of. There's a little bit higher, the number is higher if you include just like a motion or something like that, but for jury use, it's very small. And then I mentioned this notion of an expedited docket. I think we'll be experimenting with those shortly. We're looking at whether there are IT implications of courts trying these streamlined dockets, but so far I've not seen an obstacle. So we'll be pitching the idea to some trial courts very shortly. And finally, I haven't done mediators yet, I don't think. Okay, so it sounds like I'm going to be repeating myself because some of these are all interrelated. Clients are increasingly sophisticated about their ADR options. Clients are going to be asking for what's the return on investment if we choose this particular path, right? And more use of ADR pre-filing. So for mediators, I think we are going to be increasingly pressured to value cases because related to the issue of there not being juries, particularly the incoming generation of lawyers is going to be challenged about what do I do? How do I get out of this thing? What's it worth? And certainly I hear a lot from the private mediators that the first couple hours of mediation are generally facilitative. They may have waived the opening statement, and they may be just meeting in separate rooms. But by mid-afternoon or late afternoon, the parties are now asking the mediator, Zena, you've been with us all day. You talked to us about in caucus. What do you think? What's the number? And I'm nervous about that because what basis do we have for telling people what the number? A. What does that say about our neutrality at that point? Well, it says it's gone. So I think there's a lot of challenge with being asked to be evaluative at some point. But if there's a big discussion about party empowerment. If that's what people want and you're willing to do it, you give it to them. That's a discussion to have. Mediators will be coming involved with cases earlier. I think we'll have a statewide roster of private mediators at some point, hopefully within the next couple of years. I think we'll have a lot more collaboratively trained lawyers who may be more amenable to working things out rather than going through the adversarial process and then parachuting in to mediation. And I'm also very nervous about this idea of client control. Lawyers seem to be very reluctant to really level with their client. So they set some expectations when they first meet them, like, well, this is a case and we think you've got a reasonably good claim here. And then the more they get into discovery and hear what's coming in from the other side, they learn that it's not such a good case. And they want to save face for themselves. And more importantly, they want to get paid at the end when they send out the bill. So they're kind of asking mediators to be the bad cop here. And we need you to work with our client to manage their expectations, somewhat like a trial judge does in a courtroom. I see quite a lot of that going on. And I think also mediators are being asked to address poor lawyering. I remember one case in particular where the lawyer was simply unprepared to be there, but clearly did not want to look unprepared to his or her client. So by the way that we ask questions and draw out information and look at documents, we're kind of protecting the lawyer, and I think that's an unfair role that we are put in. Okay, we've talked about online dispute resolution. That's it. Yeah.
A couple of things. One, could you comment on the new intake process for special mediation?
No. I don't have anything to do with it.
Okay.
So that's a question for Belinda.
And we're experiencing it. It's a new experience for all the centers, basically. So, yeah.
Okay, well, and then I have all these entrepreneurial ideas out here, and I'm just curious, what would you think if landlords had a mediation clause in their leases naming the dispute resolution center as, I know there are questions of neutrality now, but somehow naming that disputes would be first referred to the ERC.
Oh, that's fantastic. Or any company in their company employment manual, or in Lansing, the Greater Lansing Board of Realtors, in the standard buy-sell agreement, mediation is written in there. The default around the country is usually arbitration.
Yeah.
And it used to be the Lansing Dispute Resolution Center that got all those cases, but instead they went with a private one-person mediator. Yeah. But absolutely, you could approach all of these people and say, hey, how do you manage conflict in your employee manual right now? And, write us in as the first thing. And like the post office, I don't know if they still do it, but mediation was a big part of what they did.
EEOC.
EEOC, yeah.
Just switching over to the criminal side of the courts. Recently I had some experience where I came to the conclusion that these courts are not going to try criminal cases. You negotiate a plea. And even if your attorney says, I think you've got a good defense here, but if you plead not guilty, he's going to find you guilty and you can be locked up for a longer period of time. So there's incredible pressure on people just to go along. They're just not going to accept the pleas.
Yeah, that's a tough one.
It really is.
Yeah. Any other questions, comments? Raised eyebrows?
I don't know if this is the sort of thing that you can address, but in my experience, and I've only been doing this for 2 years, but some of the cases are clearly really good for mediation, and some of them I've been uncomfortable because like in a landlord-tenant case, for instance, I know I've read the law, I've read Michigan law because cases come up so often. But sometimes you have a landlord and a tenant, neither of whom know the law, and you know that what's coming out of mediation is not going to be an outcome that you're comfortable with.
You, the mediator, is not comfortable?
Yeah, me the mediator, because, you know, the landlord perhaps was clearly at fault, and if this went on to court, the tenant might be able to get double the security deposit, or something like that, or the landlord is just being... I had one case where the landlord was really creepy, and the tenant was like, I just don't want to see this guy again, and he was withholding security deposit to maintain a relationship, I think. And, you know, I know she would have gotten her security deposit back and double had it gone into court. But she just never wanted to see the guy again. I've often thought it would be helpful to have, you know, pre-approved sheets explaining landlord-tenant law, defining a basic contract that we could just pull aside and not comment on, or, you know, just pull into the mediation and not comment on, but let the law as it's written be available in the mediation room.
And you're talking about a small claims case?
Yes, small claims.
Mhm.
Is there any?
Well, people approach that differently, you know. I mean, it's some people say, hey, it's party, you know, empowerment and whatever they want to do. You know, if it's to the point where it's illegal or nefarious, that it bothers me that I can't remain impartial, then I'm going to stop the mediation. Some people might say, would you like, well, at intake for sure, well, I assume they're saying, you know your legal rights before you come here because we don't represent you. And some people have little booklets that you get from legislators lying around the room on landlord-tenant law. You might say, would you like to take, 10 minutes and look at a website or...
Could we do that and they're not allowed their phone?
Well, so I think it's getting to the complexity of doing mediation on site, and maybe this is some advocacy for you. And by the way, we're going to have lunch and I have another list of things. But I think what I'm experiencing or paying more attention to now is that in the following the law, thought that more people are using mediation unrepresented. They have a skewed understanding of what mediation might be, and they are relying on us to give them some legal advice and all of that. So when the case is coming through intake, of course we have that conversation, and they have some real misgivings about, well, you should be able to do this because mediators so-and-so would, help us write our judgment of divorce or whatever, so that's a piece of the conversation. But in small claims, these cases are ordered to mediation, and we literally show up, and we are beginning to get matched with cases. So you don't have that time to do that intake, and we're fortunate because no one knocks on our door to kick us out of the room. So you have a little bit more time to work through the layers that case represents. But I do think, even with what you've said here, and this might not necessarily be marketing, but I think there's a need to have some kind of document that really gives some explanation to what you can expect in a mediation, what those boundaries are, because it scares me a little bit that people are coming with very complex situations and they are not represented, and they have never spoken with an attorney about it. They have taken it upon themselves to read websites, and they're interpreting that. And I mean, I don't know, I'm not a lawyer, but they seem so confident about what they should get out of the mediation, and that mediation is not a gotcha moment. So just something to help us get that message out and reinforce it that they can take with them and have, and all of that I think is helpful too. And landlord-tenant and booklets used to be available. I'm assuming they still are. Maybe that's just a matter of getting that resource. I'm not. Well, thank you all. Thank you again, Doug. I forgot to ask, did you lost the